Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, July 19th, 2023. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith, and I am John Neerman. For those who are joining us virtually, I'd ask you to please keep your microphones muted when you're not speaking. For those who are making presentations, please wait until the General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. Thank you all for being present with us today, and Ms. Smith, please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of the City of Bryan for new Texas Pollutant Discharge Elimination System permit number WQ001593001. The order of presentation will be applicant, protestants, the ED, and then OPIC. The applicant and the protestants collectively will each have 8 minutes. The ED and OPIC will each have 5 minutes. The applicant may save time for rebuttal as it bears the burden of proof on the application. And so we'll begin with the applicant, and I believe Mr. Matthews is here to represent them.
Morning, sir. Good morning. Can you hear me? Check the button.
Right now.
There you go. Perfect.
Okay. Good morning, Commissioners and Council. Ben Matthews from the law firm of Matthews and Freeland here on behalf of the City of Bryan, the applicant in this case. I was planning to then point to Alan Wolke, engineer and vice president from CDM Smith. I understand that Mr. Wolke is stuck at the train tracks that are near us here, and he's on his way. So this application was referred to the State Office of Administrative Hearings on 7 issues. The protestants appeared at the hearing through counsel with an expert. At the conclusion of the hearing, the administrative law judge issued a proposal for decision recommending that the executive director's draft permit be issued without any changes. We request that you adopt the proposed order and issue the executive director's draft permit. I or Mr. Wolke, when he arrives, will be happy to answer any questions. I'd just like to reserve the rest of my time for rebuttal.
Thank you, Mr. Matthews. Colleagues, any questions for the applicant? Seeing none, thank you, sir.
Thank you.
And we'll hear next from the protestants. Mr. Friedman, are you with us? Virtually, perhaps? Is there anyone here on behalf of the protestants on item 1? Tell you what, why don't we hear from the executive director's staff, and then we'll come back to the protestants.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Aubrey Pawelka with the Environmental Law Division. With me today is Feroz Bahora and Abdur Rahim with the Water Quality Division. Regarding the 7 issues the Commission referred to SOA, the Executive Director supports the Administrative Law Judge's conclusions for all 7 issues. The ALJ found that the prima facie demonstration established by the administrative record was not rebutted for 6 of the referred issues. The ALJ also found that the draft permit complies with the applicable citing requirements in 30 Texas Administrative Code 309. Therefore, in the absence of evidence that the draft permit violates a specifically applicable state or federal requirement, the ALJ recommended the Commission issue the draft permit and adopt all findings of fact and conclusions of law contained in the proposed order. The Executive Director respectfully recommends that the Commissioners adopt the ALJ's findings of fact and conclusions of law, grant the application, and issue the draft permit. Thank you, and we are available for questions.
Thank you. I have none. Colleagues, any questions?
No, thanks.
All right. Is there any chance that the protestants have been able to join? All right. Mr. Martinez, let's hear from OPIC, please.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. I'm Eli Martinez, Acting Director, while Mr. Arthur is away from the office. We participated in these proceedings and concluded that the applicant has met its burden with respect to each of the referred issues, save for F2, which relates to compliance with floodplain requirements. Chapter 309 establishes minimum standards applied in the evaluation of an application for a domestic wastewater permit, and these standards are predicate to permit issuance. The standard at 30913 states that a treatment plant cannot be located in a 100-year floodplain unless the plant units are protected from inundation. The Zone A FEMA map relied upon by the applicant did not provide sufficient evidence to determine that the treatment units, as proposed, were outside of the floodplain, and no evidence of how the applicant would construct or elevate units outside of the floodplain was presented at the hearing. We agree with the protestants that an applicant must demonstrate that plant units are outside of the floodplain or sufficiently designed to be protected from inundation before a permit can be issued, rather than leaving that analysis for the executive director's facility design approval process. At the plans and specs phase of facility construction, the public can no longer participate in the process or vet the assumptions of the applicant or the executive director's staff. And for this reason, Chapter 309 requires a showing of site suitability during the application process. We found that showing was not sufficiently made under this particular fact pattern. For these reasons, we respectfully disagree with the ALJ's proposal for decision and cannot support issuance of the permit without further floodplain analysis. And thank you. I'm available for any of the questions.
Thank you, Mr. Martinez. I do have a question. How does OPIC understand the chapter? I'm drawing a blank. Is it 297? 217, sorry. The 217 provision that says that plans and specs need not be submitted until after the permit is issued.
I believe that the Chapter 309 rules are predicate to permit issuance and before the plans and specs phase becomes relevant.
Sure.
So there are instances in which I think a Zone A map would be sufficient, but in this particular fact pattern, because the plant units were to be located so close to the flood boundary, I think that the evidence that was relied upon by the applicant was insufficient to be able to get to that stage. The plans and specs phase, I think site suitability had to be demonstrated at this point rather than left for a later stage.
Okay, appreciate that. Colleagues, any questions for OPIC?
No.
Okay. Okay, I understand the protestants are not going to be able to be here today, so I think we should move ahead. The applicant has reserved quite a bit of time for rebuttal. I'm not sure if you heard anything you'd like to rebut, Mr. Matthews?
Just very briefly, Commissioners, you have an extensive record before you. I do think that the record demonstrates that the 309 rules provide that plans and specs review must occur, that the facility cannot actually ever be built without that happening, and that under 309, the 217 criteria can be done either before this permit issuance or during the plans and specs review. We agree with the consideration that this must undergo review and that it cannot be built without it. We just think that the protestants and OPIC here are making more of a policy argument about how they wish that the process were to work. We're confined, in my view, to the way that the rules are outlined. In our view, in addition to the executive director's view, is that this is being processed the way that they are historically done.
Thank you, Mr. Matthews. Colleagues, any questions or comments for Mr. Matthews? All right, thank you, sir. Well, here's how I see it. Protestants only offered evidence on this one issue, floodplain, which that requirement prohibits locating the plant within the 100-year floodplain unless it's protected from inundation and damage. The application, and I'm talking about the prima facie demonstration here, the application asserts that the facility will comply with the floodplain requirement. It includes the FEMA map that's available at this time, even though that will be superseded, and it indicates how the facility might be situated with respect to that map. So that is the prima facie demonstration that the protestants need to rebut. They argue that it's not clear from the information that's been submitted whether the facility will, in fact, comply with the requirement. But I think the Chapter 217 provision is is important here in that it does not require submittal of those plans or specs until after the permit issues. The protestants also testified to personal observations about flooding in the area of the proposed facility and also about some uncertainty as to the precise location of the floodplain. But again, the applicant's plans are going to be judged against a map that FEMA has not yet issued. So we're in the situation where we're being asked to prove something that will happen in the future, and there's just not information available to do that yet. The protestants' expert testified that there may, in fact, be sufficient space on the property to comply with the floodplain requirement. And I think most importantly, the permit includes a specific provision requiring the facility to be protected from the 100-year flood. And again, this will be evaluated by agency staff based on the plans and specs and the updated FEMA map when that becomes available. So given all of that, colleagues, I agree with the ALJ that the protestants have not met their burden to rebut the applicant's demonstration that it will comply with the floodplain requirement. So pending your thoughts, I'm ready to adopt the ALJ's proposed order and issue the permit.
I don't have any additional thoughts. I think you explained everything really well, and I'm in agreement.
I think I'm in agreement as well. I want to acknowledge and say how much I appreciate OPIC's position on this issue and delving into the public's interest being served and having public participation pulled as far forward in the process as possible. However, I appreciate your pointing out, Chairman, our other rules that clearly give a space for applicants and the executive director to continue this conversation, satisfy the requirements at the date necessary between the public, potential public exposure to risk. I'm really satisfied with our process. Be that as it may, always worth voicing room to improve, but comfortable moving forward today.
Yeah. And it's already been stated, but there is a requirement in the permit that it, does not fall into the floodplain. So assuming they abide by the permit, everything should be protective. Anyway, I can make a motion if we're ready.
I think we're ready.
Okay, I'm gonna have one little clarification, but I think you'll be able to follow easy enough. I would move that we adopt the administrative law judge's proposed order, adding, quote, "and the permit shall be issued," end quote, to the end of the ordering, to the end of ordering provision 1 for clarification, that we issue the ED's draft permit, and that we adopt the ED's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Stephen Sellinger for new Texas Pollutant Discharge Elimination System permit number WQ001-593-2001. The order of presentation will be applicant, followed by the protestants, the ED, and then OPIC. Each party will have 5 minutes of oral argument. The applicant may reserve time for rebuttal as he bears burden of proof on this application. And so we will first hear from the applicant, represented by Mr. Aldridge.
Good morning, Mr. Aldridge.
Good morning, Chairman and Commissioners. Thank you. For the record, my name is James Aldridge with Winstead PC. I am appearing for the first time in this matter. As you know, Mr. Sellinger elected to represent himself at hearing. He sends his regrets and apologies. He's unable to be here this morning. And I was brought on because this is a procedurally odd case. And I think, in my opinion, Mr. Sellinger, as a pro se applicant, did a commendable job representing himself. As to the issues that you referred in your interim order to SOA for contested case hearing, we agree with the ED and the ALJ's conclusions that he's met his burden of proof on those technical issues. The hang-up is one of, in my opinion, an administrative matter. And it's one that was an issue that the ALJ added at the unilateral request of the executive director after the applicant, the party with the burden of proof, had filed its direct case in chief in this matter. And the question isn't really whether he owns the property that the proposed facility will be sited on. We think that that's not contested. In fact, I think the protestant's own witness acknowledged on cross-examination that he does. As we stand here today, the applicant owns the land. The question is, was that fact adequately introduced into the evidentiary record? And I think as a matter of administrative processing, it's really not a question of evidence. It's whether the applicant adequately amended his application to show that fact. And I'd like to direct your attention to a 1998 opinion from the 3rd District Court of Appeals styled Lake Medina Conservation Society versus TNRCC. The legal citation from Ms. Smith and her staff is 980 Southwest 2nd 511. And one of the findings of this case, and that again, I'll say that again, it's 980 Southwest 2nd 511. And one of the findings of the court there was the commission has authority to relax its administrative and procedural requirements to allow applicants to informally amend applications to correct errors like the one that was in the original one. And we think that Mr. Sellinger did that. In fact, on a couple of different occasions, he filed documents in the record that reflect that through his property holding company, he is the legal owner of this land. He did not introduce an exhibit into the evidentiary record showing that. We're not contesting that he did. But the oddity here was the addition of this issue as a contested issue after he had filed his direct case in chief, all of his testimony and his evidence. The ALJ allowed an opportunity for parties to file exhibits on this, but her order came right before Christmas. It was in the middle of the holiday season. And even as a seasoned practitioner of administrative law, my head was spinning a little bit, and I think it's pretty understandable that a pro se applicant would have been a bit confused as to what to do. So we think the record adequately reflects that he is the owner of the property. We encourage you to set aside the portion of the PFD that finds otherwise, and we think that you have the record available to you today to issue this permit. We would encourage you to do that. I'm happy to answer any questions if you have them, and otherwise I would reserve the remainder of my time for rebuttal.
Thank you, Mr. Aldridge. I have no questions. Colleagues, any questions?
Thank you.
All right, thank you. Ms. Rogers, good morning.
Ready?
Ready.
Good morning, Chairman and Commissioners. For the record, I'm Emily Rogers, and I represent the cities of Ennis and Waxahachie and Ellis County. The Commission should deny Steve Sellinger's TPDS permit application as recommended by the ALJ. While the cities of Ennis and Waxahachie and Ellis County contend that the application should be denied on all reasons that it's put forth, I'm going to focus on 2 reasons why the application should be denied: land ownership and regionalization. The PFD recommended denial of the application because Mr. Sellinger submitted an application with the permit. When he submitted his application with the commission, he did not own the property on which the facility would be located, but yet he provided false information that he did own the property. The protestants agree with the application that the application should be denied for this reason. Mr. Sellinger had multiple opportunities to correct this error, and he didn't. This county and the cities first raised the issue on land ownership in their pre-filed testimony filed on November 7th, 2022. Mr. Sellinger filed his pre-filed testimony on November 15th, 2022, but he didn't address the issue on ownership of the property in his pre-filed testimony. Again, he was afforded another additional opportunity to address land ownership on January 10th of 2023, but didn't. The applicants seeking the privilege to discharge wastewater into the state water should be held to high and exacting standards. Applicants should be required to comply with the requirements of TCEQ's regulations and what's required in the application. Here, that didn't happen. The ALJ was correct in recommending denial. The cities also recommend that the commission add failure by the applicant to comply with regionalization requirement as an additional reason to deny the application. The city of Ennis has collection facilities within 2 miles of the proposed facility, and in fact, the property is located within the ETJ. The applicant is required to request service from entities with wastewater facilities or collection systems within 3 miles of the proposed facility. Mr. Sellinger did not request service from the city of Ennis. To excuse the applicant from even the minimalist of requirements related to regionalization guts the policy altogether. Based on the PFD as adopted, if adopted, it appears that an applicant can just ignore regionalization requirements because they aren't going to be enforced at all. For these reasons, to keep regionalization requirements from utterly being meaningless, the protestants request that the application be denied on this ground as well. Again, the city and the county request that TCEQ deny the application on these 2 grounds as I've described. I'm available for questions, and I thank you.
Thank you, Ms. Rogers. Colleagues, any questions? I have none. Thank you. Let's hear next from the Executive Director staff.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Aubrey Pualka with the Environmental Law Division. With me today is Feroz Bahora and Abdur Rahim with the Water Quality Division. The Executive Director agrees with the Administrative Law Judge's conclusions and findings as referenced in her proposal for decision. The Administrative Law Judge found that the draft permit meets the requirements for regionalization, is protective of water quality and the existing uses in accordance with the Texas Surface Water Quality Standards, and contains adequate licensing requirements for the operator of the facility. Additionally, the ALJ found that since the applicant did not own the land where the facility will be located, the application should be denied. The Executive Director recommends denial of the application and adoption of the proposed order with incorporation of the minor correction noted in the Executive Director's exceptions to the proposal for decision. Thank you, and we are available for questions.
Thank you, Ms. Pollock. I have none. Colleagues, any questions? All right, let's hear from OPIC. Mr. Martinez.
Good morning again, Chairman. We participated in these proceedings and concluded that the applicant met its burden with respect to each of the issues that were adjudicated at the hearing, save for the issue of ownership. Section 305.43A of our rules require the owner of a facility to apply for a TIPD's permit, and Section 9 of the TIPD's application form requires that either the applicant own the land where the proposed wastewater treatment facility will be located or provide proof of a property interest in that land. The application indicated that Mr. Sellinger was the landowner, and there was no attachments to that response that was showing a relationship with Waxahachie Creek Ranch, who the record shows to have been the actual owner at the time of the application. Because ownership is a threshold issue in permit issuance, we support the findings of the PFD and therefore recommend that the ALJ's order be adopted.
Thank you, Mr. Martinez. Didn't mean to interrupt you. Okay. Colleagues, any questions for OPIC? All right, Mr. Aldridge, you've got, we won't start the clock until you start speaking, but you have you've got 95 seconds left, sir.
Okay, thank you. And earlier I said we agree with the Executive Director and the ALJ on the issues that you referred. We also agree with OPIC as well. I didn't mean to leave them out. Those parties all agree that as to the technical issues, this application and this applicant met its burden of proof and that the permit should be issued. So we're back to the land ownership issue, and Ms. Rogers pointed out that the first time any party brought this up was in November of last year during the contested case hearing proceedings. This was not an issue that was raised in any comment letter or any hearing request. It was not an issue that you referred in your interim order, and so at the minimum, we request that you give some regard to the fact that procedurally this was added at a very late time. And if you don't see fit to grant the permit today, then perhaps what you could consider doing is remanding this matter to SOA on a limited issue and direct the ALJ to reopen the record to allow testimony and evidence as to who owns the land so that the permit can get issued. It seems to me a bit severe and rather unjust for the solution today to be flatly just outright denial of the application for a pro se applicant who's really just trying to exercise his land ownership rights. So we'd encourage you to consider giving him an opportunity to file this evidence if that's what you require, and send us back to SOA if not grant the permit today.
Thank you, Mr. Aldridge. Right.
Thank you.
I'm seeing no questions. Yeah, thank you,
very
sir.
much.
Thank you. I appreciate the presentations this morning. And what I heard was helpful and instructive, but it really didn't change the views that I formed coming in this morning. And colleagues, what I'm going to do is recommend some changes to the findings of fact, but nothing that would substantially change the ALJ's conclusions on the major issues, nor the recommendation to deny the application. The dispositive issue is whether Mr. Sellinger not is the owner, but was at the time he submitted the application, October 1, 2020, owned the land or held the landowner's consent to submit the application. He did not, nor was he denied due process. He had several opportunities consistent with SOA rules to present evidence and to cross-examine witnesses. What this comes down to, I think, is that the application contained a fatal defect. It appears that that was not discovered until only after the applicant had expended significant resources on the application. That is unfortunate. I think it doesn't take an attorney to understand the instructions in the form. You know, they're designed for a layperson. In any event, it's been an unfortunate, I hesitate to use the word waste, but maybe that's the right word, waste of resources on the part of the applicant. But that's where we are. I also want to add that the protestants have borne quite a cost as well, as has our agency. That doesn't change the fact that there is a defect here. In any event, colleagues, if it's all right with you, what I'd like to do is read a motion that would include the few changes to the findings of fact that I mentioned, and then we can discuss it on the other side.
Which numbers on the findings of fact?
So
just
I
can follow?
am looking at, and I can preview those for you, finding of fact number 35.
Okay.
I think ultimately that's not relevant. And finding of fact, and so I would delete that one.
Okay.
On finding of fact 59, I would restate that, and I'll just preview for that. I would rewrite it to state that Sellinger was not the owner of the land of the proposed facility when the application was filed. And then the final change is just to correct the date in finding of fact number 1, consistent with the request by the executive director to the ALJ, and that was also recommended by the by the ALJ.
Okay. I'll probably be in agreement. You know, I do agree with everything you've already previously said too. I'm not going to try and regurgitate it, but I thought the way OPIC said it was pretty good. It's, you know, it's a threshold issue. That's kind of the bottom line for me, and I think I'll be supportive of whatever your motion ends up being.
I'm good.
All right, colleagues, I move that we deny the permit application of Stephen Sellinger for TPDES permit number WQ00159320001. I further move that we adopt the executive director's response to comments to the extent that it is not inconsistent with the commission's decision to deny the application. And I move that we adopt the ALJ's proposed order with the following 3 changes. 1, delete finding of fact number 35 because this finding is not relevant to the conclusion that connecting to the city system is not required due to cost. 2, to more accurately reflect the evidence in the record, revise finding of fact number 59 to state, quote, Sellinger was not the owner of the land of the proposed facility when the application was filed, end quote. And finally, the third change is to change the date in finding of fact number 1 from September 21, 2020 to October 1, 2020, as requested by the executive director in her exceptions and recommended by the ALJ in her June 6, 2023 letter. And that is my motion, and I'm ready to entertain additional thoughts.
I would second it, so I don't have any thoughts. Okay, I second the motion.
The motion, we're ready for a vote? Looks like we are. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by East Central Special Utility District for approval to levy an impact fee. The parties have been notified that the commissioners will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. Colleagues, we have one request on this item. That is from Ms. Perez. She does not live within the special utility district, would not be subject to the fee, and raises concerns only about another project. So I think we need to deny her request and approve the application. As part of our order, we should, though, include the requirements identified in the executive director's technical memoranda. I think you've seen that. And just specifically, those requirements address the deposit of interest on and records availability for the funds that are collected, as well as requiring TCEQ's approval of future fee increases.
I agree.
Likewise, I think I have a motion that would capture that.
Okay.
I move that we deny the hearing request filed by Ruth Perez, find that this impact fee is reasonable, equitable, and necessary as a mechanism to finance improvements to serve the district. Further move that we approve East Central SUD's impact fee application, including the impact fee study, report, and capital improvement plan and impact fee in the amount of $3,806 per equivalent single-family connection. I further move that we require that any increase in the amount of the impact fee must be approved by the TCEQ, and move that we require that all funds collected through the levy of the impact fee shall be deposited in interest-bearing accounts and, combined with the interest earned, shall be utilized for repayment of debt and/or construction of improvements as indicated in the 2022 impact fee study report. The records of the accounts into which impact fee revenue is deposited shall be open for public inspection and copying during normal business hours.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the petition for the creation of Hunt County Municipal Utility District Number 5. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, as you know, requests for contested cases on MUD petitions are governed by Chapter 55 of our rules, which requires the commission to grant the requests of persons who meet the procedural and substantive requirements to be considered affected persons. And these requirements include a timely hearing request that identifies the requester's location relative to the activity that's the subject of the petition, and that identifies a personal justiciable interest not common to members of the general public. It's a familiar standard for us. What may be a little bit different is, since this is not a House Bill 801 hearing, we are not required to refer specific issues to SOA. So our task here is simply to identify and refer affected persons. And on this item, we just have a single request. It's from the city of Caddo Mills. I believe the city has met the procedural and substantive requirements to be entitled to a contested case. The city filed a timely request. The proposed MUD is entirely within the city's ETJ, and the city identifies several relevant concerns that are not common to members of the general public, and that includes impacts to water quality and drainage, the availability of other services, as well as local government consent. So I would grant the city's request and refer the matter both to SOA, and in this case, I think ADR may be useful as well.
I'm in complete agreement.
I agree.
I'll make a motion then, and I would move that we grant the hearing request of the city of Caddo Mills, that we refer the matter to SOA for a contested case hearing on the petition, and that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of the petition filed by Steve Sellinger for the creation of Schenkel Road Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, as I just noted, petitions or requests for contested cases on MUD petitions are governed by Chapter 55 of our rules. So we're looking for persons who have made a timely hearing request that identifies their location relevant to the MUD boundaries, and that identifies a personal justiciable interest not common to members of the general public. And let me expand a little bit on what justiciable means in the context of a MUD petition. The Water Code identifies 3 bases for our commission's, TCEQ's jurisdiction, and these considerations are the availability of comparable services from other systems or authorities, the reasonableness of projected costs together with tax and utility rates, and number 3, the effect on the land with respect to 7 specified factors. And these factors are set out in Texas Water Code Section 54.021B and are as follows: land elevation, subsidence, groundwater level, groundwater recharge, drainage, water quality, and finally, number 7 is the total tax assessments on all land in the district. So again, we're looking for requests that invoke the commission's jurisdiction in a way that's personal to the requester. And as you know, we had over 250 hearing requests on this item. Several of the requests raised no personal interest at all. Many more raise issues that are not within the commission's jurisdiction on this petition. That is, they're not justiciable, as I've just described. For example, concerns about roads, traffic, wastewater effluent, wildlife displacement, housing density, impacts to emergency services, and concerns about development generally are not a legal basis for the commission to grant a hearing request. A few of the requesters identify a justiciable interest, but don't say how they would be personally affected. We also have to deny those requests. Some describe themselves as heirs to property without indicating whether they actually own the property or use the property or reside at the property. So that doesn't quite meet the personal connection that we need to grant a hearing request. Other requesters simply reside too far from the proposed district boundaries to be affected in a manner different from the general public. So ultimately, after reviewing the requests, I found 19 that I feel met the procedural and substantive requirements to be entitled to a hearing. And I'm happy to read through those. I can read them into a motion if you like. We can discuss on the other side, or
I'm just double checking. I think I have found the same amount.
so to be clear, I'm talking about 19 requests.
I was
And
about to
some
say,
of those requests were
not
filed
individuals
by-
necessarily. Yeah.
by more than one person.
Yes, because I have more than 19
I
technical
think there's
people.
just over 24 people on 19 requests.
Okay, I could probably just follow along if you wanted to make a motion and read the names out.
Tell you what, the motion is not long. I mean, the long part is the list of
names,
names.
yeah.
Yeah, the rest of the motion is really pretty short. So I think it's maybe worth the risk. And we'll read the list of names again if we need to.
Okay.
Does that work? Okay. And again, we can discuss this on the other side, but colleagues, I move that we grant the hearing requests of the following people: Robert Alston, Carol Alston, Jack and Vicky Schmilar, Jimmy and Stacy Driscoll, Emil and Judy Langer, Leslie Mock, Nancy Mock, Cheryl and Stuart Maddox, Ernest Martinek, Jennifer Martinek, Margaret Martinek, Marvin Lee Martinek, Charlie Pozar, Adele Pozar, Jeff Pozar, Alan and Deborah Prockel, Randy Lynn and Kathy Ray, David and Renee Stiff, and Jacob Zanell. I further move that we deny the remaining hearing requests and that we refer the matter to SOA for a contested case hearing on the petition. How'd we do?
I would second that, but I don't want to jump too far ahead.
I second the motion.
Great. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the application for the creation of Denton County Municipal Utility District Number 12. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So we have yet another MUD petition here, and like item 4, there's just one request for contested case hearing, this one by the city of Sanger. The city filed a timely request expressing concerns relating to the availability of comparable sewer services, which is a personal interest in that the MUD would be located entirely within the city of Sanger's sewer CCN. I believe the city has met the procedural and substantive requirements to be entitled to a contested case hearing. And pending your thoughts, I'm ready to grant them that.
I'm in agreement.
Likewise, I would move that we grant the hearing request of the city of Sanger and refer the matter to SOA for a contested case hearing on the petition.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 7 is the consideration for adoption of 4 total maximum daily loads for indicator bacteria in the Neches River tidal of the Neches River Basin. The executive director's staff is here to present this item.
Good morning.
Good morning. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today are Wyatt Eason with the Total Maximum Daily Load Program and Aubrey Pawalka with the Environmental Law Division. Today, the Executive Director is requesting the consideration for final adoption of 4 total maximum daily loads for indicator bacteria in Neches River tidal. The TMDLs cover 4 assessment units in one segment within Jasper, Orange, and Jefferson counties. The stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by TCEQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. I have none. Colleagues, any questions?
No questions, thanks.
Not at this time, thanks.
And Ms. Smith, has anybody signed in to speak on this item?
No one has signed in on this one.
And Mr. Martinez, what is OPIC's view?
Good morning again. OPIC supports adoption of the 4 proposed TMDLs for indicator bacteria in the Neches River tidal as required by the Federal Clean Water Act, Section 303D, for approval as certified updates to the State of Texas Water Quality Management Plan.
Thank you, Mr. Martinez. I really, colleagues, don't have anything to add other than my appreciation for staff and for the stakeholders and all the work that went into developing these TMDLs. I'm ready to move forward with adoption.
Total agreement. There's usually not a whole lot of discussion on these items, but there's a whole lot of work that goes into them. So thank you, Nicole and Wyatt and Aubrey. And you've been up here the whole time, I think. You've had a busy day today, but I'm ready to just move forward.
I'll only add that I'm grateful for the stakeholders and also some of the public comments efforts on this one. I note there's interest and this always stirs up, not always just the direct conversation that we hope for on all of our programs with the members of the public necessary to answer or respond to certain pieces. It also catches people's piques their interest on other unrelated issues. So thank y'all for the ever-growing workload that our staff continues to juggle. But thanks also to those stakeholders who actively worked and met on a webinar, another meeting to give their input into this plan, make it a better plan. Thank you.
Oh, go ahead. Well, I can make motion or, okay. Then, if we're
we
ready,
took
then I would move that we adopt 4 total maximum daily loads for indicator bacteria in the Neches River tidal of the Neches River Basin as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 8 through 38, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 8 through 38. The total assessed administrative penalties are $1,251,578, with $155,052 deferred, $499,732 applied toward supplemental environmental projects, and $596,794 to the general revenue. We respectfully request the remand of item 36, Jeffrey H. Brennan, DBA P&B Water, because we received a signed order and the initial payment yesterday, July 18th, 2023. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No questions.
None, thank you.
All right. Ms. Smith, is anyone signed in to speak?
On items 10 through 18, 20, 22, and 24, we have individuals here who are available to answer questions if the commission has any, but no one has asked to address the commission.
Thank you. And Mr. Wayne, are you taking this one? Mr. Martinez.
Mr. Wayne will serve as a resource.
Okay.
But we've reviewed these items, their proposed penalties, any comments that were submitted by the respondents, compliance histories, adherence to the penalty policy, notice and other procedural requirements, and at this time we are satisfied that these items do in fact comply with the relevant statutes, rules, and policies of the Commission. And OPIC is therefore prepared to support the adoption of the proposed enforcement orders listed in items 8 through 38 of today's Commission agenda.
Thank you, Mr. Martinez. Colleagues, I agree. I'm ready to move forward with this docket, except for item number 36.
As am I. I would move that we remand item 36 to the executive director and that we adopt items 8 through 35 and 37 through 38 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 39 is the consideration of the monthly enforcement report, and the executive director's staff is here to present the item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through May. There were 702 effective administrative orders issued, and of those, 88 contained supplemental environmental projects. These orders assessed a total of $8,712,903 in penalties, with a payable amount of $5,047,292. $2,366,339 are to be paid toward supplemental environmental projects. 10,706 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,552 enforcement action referrals have been received. There are 2,287 pending administrative orders with 1,131 cases that are on the backlog. 180 cases are pending at the Attorney General's office for representation in district court, and 13 judgments have been issued. 2,246 cases are being tracked for compliance. We do have an update on the Enforcement Division staffing. We're really excited to report that we've recently had a very successful express hire event, and we have many new hires that just started in the past few weeks, with more coming in the next few weeks, or in the coming weeks. We currently only have a vacancy rate in the Enforcement Division of 9%, which is significantly lower than our approximate 30% vacancy rate that has impacted our productivity and timeliness. We are highly focused on training these new staff and retaining them, and along with our experienced staff, we are and will be dedicated to training these new folks to develop and track our enforcement actions. And in addition to hiring and training these new hires, we are continuing to identify areas of the process that will allow for a more streamlined and timely process. Otherwise, we have included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none, but I'm very glad to hear the news about our success on the staffing issues we've had. Colleagues, any questions?
No questions. Thanks for the great report.
Yeah, I just want to echo that sentiment, Chairman. Really, really pleased to hear that we're having some success in filling the vacancies in this part of our agency, which I think has been a really critically felt need. So glad to hear it. Thank you.
Ms. Smith, has anyone signed in to speak?
No one has signed in on this item.
All right, and what is the OPIC's view?
No comments on the report, Chairman, though we do, as always, appreciate the effort it represents to ensure that the protections afforded by our rules and the permitting provisions we apply to our permits and the authorizations for public health and the environment are appropriately adhered to, especially in light of the staffing challenges that we're faced.
Thank you, Mr. Martinez. And Ms. Cordell, thank you and your team for the report. We appreciate it. Ms. Smith, I'll ask you to please call the next item.
Item number 40 is the consideration of the withdrawal of the proposed amendment to 30 Texas Administrative Code, Section 116.615, regarding control of air pollution by permits for new construction or modification. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm David Munzenmeyer with the Air Permits Division. With me are Sam Short with the Air Permits Division and Booker Harrison with the Environmental Law Division. We are requesting withdrawal of the proposed amendment to Chapter 116, Control of Air Pollution by Permits for New Construction or Modification. The proposed amendment to 116.615.2 would have added language under a new paragraph to require that for any requested on-site movement of a concrete batch plant authorized by the air quality standard permit for concrete batch plants, the owner-operator shall submit a new or amended registration and fee and comply with the public notice requirements, including the opportunity to request a contested case hearing, unless the new location is greater than 440 yards from any property line. The proposed amendment was published in the March 10, 2023 issue of the Texas Register. A public hearing was held on April 6, 2023 in both English and Spanish, and the public comment period closed on April 10, 2023. We received 3 comments during the comment period, all expressing concern that the proposed rule was not consistent with Texas Health and Safety Code, Section 382.058C, as a means for measuring the distance to determine whether a person may be an affected person. No comments were received in support of the proposed change. The Executive Director has elected to withdraw this rulemaking project to ensure any proposed rule language remains consistent with existing statute under Texas Health and Safety Code, Section 382.058C. In conclusion, staff respectfully recommends withdrawal of this rulemaking for Chapter 116. Thank you, and we are available to answer any questions.
Thank you, Mr. Munzenmeyer. I have none. Colleagues, any questions? All right, Ms. Smith, has anybody signed in to speak on this item?
Ms. Margaret Ward.
Ms. Ward, good morning. And make sure the green light is on your microphone.
Okay.
My name is Margaret Ward, and I represent the Texas Aggregates and Concrete Association, and TACA is supportive of the proposed withdrawal of this amendment.
Thank you, Ms. Ward. Appreciate that. And let's hear next from Office of Public Interest Counsel.
Good morning again, Chairman. We reviewed the proposed amendment, the comments that were submitted regarding the project and the proposed withdrawal. The subject of these efforts has been raised by our office before, including in our annual report and proposed rulemakings, to ensure those who reside within close proximity to concrete batch plants receive meaningful opportunities to participate in our processes. It's therefore a project that may facilitate our mission of analyzing and apprising the Commission of public interest issues related to concrete batch plant authorizations. Yet it is also our duties as attorneys to maintain consistency between our rules and statutory provisions like those found in the Texas Health and Safety Code, Section 382058C. We therefore have no objection to the ED's withdrawal of this proposed rulemaking, as we too aspire to simultaneously accomplish both tasks of protecting public participation while also maintaining consistency within our rules. However, we would like to note some observations and some features of this rulemaking that we supported and that we hope will be present in any future evolutions or iterations of the project. Firstly, our reading of the proposed amendment did not arrive at the same conclusion that the rulemaking on its face was inconsistent with the Health and Safety Code. We read the proposed rulemaking as a procedural privilege to adjust the layout of a proposed facility even after a different configuration was represented in the application without the need for notice or further technical review, as long as there's a certainty of at least 440 yards between the plant as revised and a permanent residence. The property line language achieved this certainty and provided that procedural mechanism for adjustment, but we did not interpret this to contravene or modify the substantive requirements of the Health and Safety Code, its setback requirements, public participation processes, et cetera, which would have all still applied. Secondly, the proposed amendment seemed to allow for participation of a resident who did not yet live in an existing residence at the time of the original application, or who had not yet built a residence within 440 yards of the modified plan, but found themselves in this position after the modification had been proposed. And this was due to the requirement for renotice at the time of the desired modification, which we believe in turn would have necessitated another snapshot in time of potentially affected residences. We support this feature. We believe if an applicant initiates a change, affected residents at the time of that requested change should be afforded an opportunity to participate in the permitting process, particularly in light of the relatively long 10-year duration of the standard permit. Thirdly, we would welcome the opportunity to participate in thinking through what such a new snapshot may look like, who's allowed to participate, whether or not we would rely on the applicant to do and to certify that work, or if this would be tasked instead to the executive director, and what burden that may represent to agency resources, as well as other access issues like whether or not revised plot plans would be available to the public showing the new emission source locations. And lastly, because this is an increasingly larger topic to many of our citizens as Texas continues to build, to grow, and to thrive, we would be happy to participate on the rulemaking team as the evolution of the originally proposed rulemaking proceeds. And so please consider that our formal invitation to do so.
Thank you, Mr. Martinez. Appreciate the detailed thoughts on that. I'm sure they'll be instructive as we move forward on this. Colleagues, here is my understanding of this rulemaking. It was initiated by the commission and is entirely voluntary, so we're not on any particular deadline. This is not necessarily a statutory implementation. The purpose is to address a concern that's been raised about the procedural rights of persons who reside near a proposed concrete batch plant. And specifically, we're talking about the right to request a contested case hearing. And that concern is that a neighbor who resides more than 440 yards from a concrete batch plant and is therefore not entitled to a hearing might sometime later find themselves living within 440 yards of that plant if the operator were to move the facility to a different location on the property. We have looked. I'm not aware that that has ever happened. But as Mr. Martinez points out, OPIC has raised this issue numerous times, including in its annual report to the commission. And to be even-handed and consistent with the statute, the commission, I think, needs to make it clear that persons who reside within 440 yards of where a concrete batch plant would be located will have an opportunity to request a contested case hearing. And this, of course, includes the case where an operator elects to move the plant to another location on the property. I want to emphasize that this rulemaking, if it's not already abundantly clear, relates only to procedural rights. It does not touch anything that would affect the protectiveness of the standard permit. I also want to be very clear that the 440 yards is a legal standard. It's not a health-based standard. Under the terms of the permit, the science-based buffer that is protective of human health cannot extend beyond the property line. The 440 yards, which of course extends beyond the property line, is simply the legislature's definition of who should enjoy the procedural right to request a contested case hearing. Anyway, I understand that there are concerns expressed in the comments and other concerns that the proposed rule language is not quite there yet. And so, and I also understand that we're up against the notice clock on this, and rather than rush it, I think we need to take our time, re-notice an amendment and get this right. So those are my thoughts. Commissioner Lindley.
I'm in agreement. I don't have anything to add on to that.
Well said. I too am in full agreement, and I would only echo some of the points raised by OPIC. I hope to see some of the aspirational points in the current draft preserved in a more attainable and efficient, operationable set of requirements for us to hand down to the public so that they understand where, on what I think is a very bright line, tight focus from the legislature, acknowledging the public sensitivity to these sites, to these projects, and this activity, 440 yards out, well said, that draws the legal line within which the public are able to enjoy, it's a weird way to say it, but to enjoy the right to contest and go into court in contesting these permits. So to that end, I'm pleased to take our time and make sure we get it right. And I hope that we can have some conversations about this with not just stakeholders, but if interested persons in the public. This is a very hard issue to capture public interest because the public doesn't care until the issue materializes in a very specific example in their backyard, and then they shift out of. Anyway, I'm pleased with our agency taking its time to get this process right, and I'm good.
Thank you, Commissioner. I guess more to follow.
Yeah, we need to, I mean, I have a motion, or if there's more to, I'm willing to make one. I don't know if we necessarily.
We may be finished with the discussion. And we can act to withdraw it, or we can not act, and it will, in time, just sort of expire. I think it's not going to make a difference unless Executive Director staff has a preference.
I think if we make a motion, it might move things ever so slightly faster, is my understanding. So that's why I was going to make one. But again,
Let's do it.
okay.
No harm in it.
Well, we'll see if you support it. I move that we approve the withdrawal of the proposed amendment to 30 Texas Administrative Code, Section 116.615, as recommended by the Executive Director, and issue the Executive Director's proposed order.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Thank you all. Ms. Smith, when you're ready, please call the next item.
Item 41 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Section 330.647, the approval of regional and local solid waste management plans. The Executive Director's staff is here to present this item.
Good morning. I'm not hearing you.
Good morning.
There we go.
Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Jess K. Ramkin with the Waste Permits Division. With me is Heather Haywood with the Environmental Law Division. In accordance with 30 Texas Administrative Code 330.641, the Executive Director respectfully requests the Commissioners to approve and adopt by rule the 24 approved regional solid waste management plans developed by the Texas Councils of Governments. This rulemaking would amend 30 Texas Administrative Code Section 330.647 to incorporate the plans by reference. The regional solid waste management plans contain goals for proper waste disposal, waste diversion from landfills, and waste minimization, as well as goals for increasing recycling and reducing illegal dumping of waste in each region for the period of 2022 through 2042. They include regional growth estimates for population, commercial and industrial sectors, and solid waste generation. The plans were developed by each council of governments and approved by their boards of directors. The proposed rules were published in the February 24th, 2023 issue of the Texas Register. A public hearing was held on March 23rd, 2023, and the public comment period closed on March 27th, 2023. The rule team received and responded to public comments and did not make any changes to the rule language based on those comments. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 330. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. We are available to answer any questions at this time. Thank you.
Thank you, Mr. Ramkin. I have no questions. Colleagues, any questions?
No, thank you.
Ms. Smith, has anyone signed in to speak?
We have people signed in, but they indicated they don't wish to address the commission, and their presence will be noted for the record.
Thank you. And what is OPIC's view?
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. I'm Jennifer Jamison on behalf of OPIC for the record. Our office has reviewed this rulemaking as well as all related public comments, and OPIC supports adoptions of amendments to 30 TAC Chapter 330 regarding the 24 approved regional solid waste management plans developed by the Texas Council of Governments. Accordingly, OPIC supports adoption of this rulemaking as proposed by the Executive Director.
Thank you, Ms. Jameson. Colleagues, I agree with that. I want to thank the COGS for all their work in developing these plans, and I'm ready to adopt them.
I agree.
I'm in agreement as well. I would move that we find that the 24 regional solid waste management plans conform to TCQ requirements and adopt the amendments to 30 Texas Administrative Code Section 330.647 as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to items 42 through 45, which are our quadrennial rule reviews for chapters 17, 18, 298, and 334 of the Texas Administrative Code, Title 30. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 42, 43, 44, and 45, the adopted rule reviews of 30 Texas Administrative Code, Chapter 17, Tax Relief for Property Used for Environmental Protection, Chapter 18, Voter Approval Tax Relief for Pollution Control Requirements, Chapter 298, Environmental Flow Standards for Surface Water, and Chapter 334, Underground and Above-Ground Storage Tanks. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the need for the rules within the chapters continue to exist. The proposed notice of the review for 30 TAC chapters 17, 18, 298, and 334 published in the March 10, 2023 issue of the Texas Register with a 30-day comment period. No comments were received for these rule review projects. Based on the review of these chapters, the Executive Director has determined that the reason for the rules in chapters 17, 18, 298, and 334 continue to exist. In conclusion, we respectfully recommend approval of the adoption of the rule review of chapters 17, 18, 298, and 334. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. The project managers and attorneys are here with us to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions?
No, thank you.
Ms. Smith, has anyone signed in to speak?
No.
Thank you. And Mr. Martinez, what does OPIC think?
Good morning. As no rules were found to be obsolete, we conclude that the initial reasons for adopting the rules of chapters 17, 18, 298, and 334 continue to exist. Additionally, no comments were submitted and no hearings were held on these reviews, so we feel comfortable at this time supporting the readoptions listed in items 42 through 45 of today's agenda.
Thank you, Mr. Martinez. Colleagues, I agree with that entirely and won't restate it.
I agree, and I will move that we adopt the rule revisions and re-adopt the rules in 30 Texas Administrative Code, chapters 17, 18, 298, and 334 without amendment, as recommended by the executive director.
I second the motion.
And you said the rule revisions, but I think you meant rule reviews.
I do that
Just
all the
wanted to
time.
clarify.
I do mean rule reviews. Thank you.
I second the amendment as clarified.
The motion has
Second the
been
motion as clarified.
motion has been made and corrected. I think this is close enough for government work. We'll take a vote. Corrected and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Terribly worried about our legal exposure on this now, given the sloppy motion. Commissioner Lindley? No, I'm teasing. I don't think we're going to be sued over this one.
If that's how I go down, that's how I go down. I don't know.
Sure, we've invited lawsuits elsewhere on the agenda today, but not on this particular item. Ms. Rico, thank you again. And Ms. Smith, I'll ask you to please call the next item.
Item 46 is our public comment session, and we don't have anyone signed in to speak at this time, but you can pause and see if there's anyone here that wants to address the commission.
Everyone is running the other direction. No one is approaching the podium. So I think our work is done on item 46. If you'll please call the next items. Oh, I think I hear something. Is there anybody joining us virtually who'd like to make a public comment?
No, they're same thing.
Okay. All right, Ms. Smith, I'll ask you to please call the next items.
The next items are items 47 through 50, and they are for closed session. The commission will meet in closed session in Building E, Room 211S at, shall we just say 10:45? At 10:45, as permitted by the Open Meetings Act to take up matters pursuant to Government Code Sections 551.071 and 551.074.
The time is 10:42 a.m. We are in recess.
The commission met in Building E, Room 211S for closed session from 10:53 a.m. until 11:03 a.m. on items 48 through 50 as posted and noticed pursuant to Texas Government Code, Section 551074. No action was taken. This agenda stands adjourned, and the time is 11:10.